The role of professional nursing continues to expand and incorporate increasingly higher levels of expertise, specialization, autonomy, and accountability from both legal and ethical perspectives. This evolving role has caused new concerns for the nursing profession in awareness of the interaction of legal principles. This is part one of a three-part lesson of legal issues in nursing healthcare. Law refers to any system of regulations that govern the conduct of individual within a community and/or society in response to the need for regularity, consistency, and justice. All nurses benefit by understanding the legalities. Let's talk about statutory law. These are laws that are written and enacted by legislative bodies. Violations are criminal offenses and are punishable by fines or imprisonment. Now let's discuss federal statutes related to nursing and healthcare. Federal statutes have a major effect on nursing care. They mandate a minimum standard of care in all settings that receive federal funds, such as Medicare and Medicaid. The Federal False Claims Act make it an offense to submit a false claim to the government for payment of health care services, also known as whistleblower. These are reports that are false or fraudulent claims. Let's look at a few statutory law. We have the Emergency Medical Treatment and Active Labor Law. This prohibits refusal of care for indigent and uninsured patients seeking medical assistance in emergency departments. It prohibits transfer of unstable patients, including women in active labor, from one facility to another. It is applicable to non-emergency facilities and urgent care clinics. Then we have Americans with Disabilities Act of 1990. This prohibits discrimination against persons with disabilities by removing barriers that might prevent the same opportunities available to persons without disabilities. We had the Patient Self-Determination Act of 1990. This requires federally funded hospitals, where they receive Medicare or Medicaid, to inform adult patients in writing about their right to make treatment choices and to ask patients if they have a living will or a durable power of attorney. The Health Insurance Portability and Accountability Act of 1996 became Public Law number 104 through 191, also known as HIPAA. It ensures confidentiality of a patient's medical records, sets guidelines for maintaining the privacy of health data. And we have the Patient Safety and Quality Improvement Act. This allows certain disclosures of patient safety data. Then we have some state statutes. We have the Nurse Practice Act and Board of Nursing Rules and Regulations. They define the scope and limitations of nursing practice. They vary from state to state, but common elements include definition of the term registered nurse, description of professional nursing functions, standards of competent performance, behaviors that represent misconduct or prohibited practices, grounds for disciplinary action, and fines and penalties for violations. Each nurse should own a copy and should understand the content. Violations of the Nurse Practice Act or rules and regulations are governed by licensing boards. They have the authority to hear and decide cases against nurses. Penalties that may be imposed are issuing a formal reprimand, establishing a period of probation, levying fines, or limiting, suspending, or revoking the nurse's license. Inadequate and often unsafe nurse-patient ratios continue to plague nursing. Nurse-patient ratio and mandatory overtime statutes include that California was the first to enact a law in January 2004 that mandates the establishment of minimum nurse-to-patient ratios in acute care facilities. For example, critical care units, step-down and medical surgical units, and maternity departments. Research indicates that improved nurse-to-patient ratios are associated with lower failure to rescue rates and lower inpatient mortality rates. The federal government and states seek to protect at-risk individuals by requiring nurses and other healthcare providers to make reports. Reporting statutes. We have Child Abuse Prevention and Treatment Act and reporting statutes. Laws that mandate reporting of specific health problems and suspected or confirmed abuse. Health professionals must report the following under penalty of fine or imprisonment for failing to do so: infant and child abuse, dependent elder abuse, or specified communicable diseases. Most laws grant immunity from suit within the context of the mandatory reporting statute. Laws that are created to protect the public and ensure the safe and effective profession of healthcare services are managed by state legislation to have institutional licensing laws. All facilities that provide healthcare services must comply with licensing laws. Generally, what is contained within these laws are minimum standards for maintenance of the physical plant, basic operational aspects for major departments such as nursing, dietary, clinical labs, and pharmacy, essential aspects of patient rights and informed consent process, and copies of licensing laws that can be obtained from the state health department. The ANA implicates that standards of professional performance include the nurse working, utilizing the Nurse Practice Act in congruence with state and federal laws. And this should be used along with the standards of quality practice to guide nurses. This concludes part 1 of 3 parts of legal issues in nursing and healthcare lesson. If you have any questions related to course content, contact the instructor.